Section 2 creates the offence of dissemination of a terrorist publication. Dissemination of a terrorist publication can be sharing or posting a book or a tweet, a CD or a podcast, a TikTok or a YouTube clip, a photograph or a social media tile. This terror offence, like other terror offences, are widely drawn and therefore easy to commit for both the criminal and the ignorant. For a person to commit a Section 2 dissemination of a terrorist publication offence, 3 tests need to be met. The first test is whether the publication in question is a terrorist publication. There are 2 ways in which a publication can be a terrorist publication. The first way is if the publication is likely to be understood by some or all of the persons to whom it is or may be disseminated as a direct or indirect encouragement to commit acts of terrorism. An example of a direct encouragement could include an administrator of a web page post his notes from various talks to engage in acts of terrorism. Indirect encouragement, on the other hand, refers to publications which glorifies past, future or generally terrorism. And this is the most important point, is a matter from which a person could reasonably be expected to infer that what is being glorified as conduct that should be emulated by him in existing circumstances. For example, publishing online tweets that glorifies a banned group's past violent acts against a government could easily be argued to be reasonably expected to infer that such acts should be committed today. And by the way, the reference to government here means any government around the world. The second way a publication can be a terrorist publication is if the matter contained in it is likely to be useful to a would-be terrorist, to some or all persons it is or may be disseminated to, such as someone sharing a magazine containing bomb-making formulas via a signal group. Once it has been determined that the publication is a terrorist publication because it either encourages terrorism directly or indirectly, or is useful to a would-be terrorist, the second test concerns the meaning of dissemination. Now that's quite easy to understand. Dissemination is if a person distributes or circulates a terrorist publication, and this can be done in a number of ways, such as giving, selling or lending a terrorist publication, offering a terrorist publication for sale or loan, providing a service to others that enables them to obtain, read, listen to or look at such a publication. The offence is also committed by doing acts preparatory to a terrorist publication's dissemination and holding it with a view of dissemination, such as holding an online library of a terrorist publication on the dark web. Dissemination can be committed by sharing terrorist publication among friends with no financial gain, such as sending a WhatsApp of a beheading clip to a friend. The third test relates to the person needing to have the necessary state of mind to commit the offence. Dissemination of a terrorist publication can either be committed intentionally or recklessly. Intention as a state of mind refers to a person who basically wants others to be directly or indirectly encouraged to engage in terrorist activity. A reckless state of mind refers to a person who knows sharing the terrorist publication to the receiver risks being understood as direct or indirect encouragement for the receiver to commit acts of terrorism, even though it is not the person's intention, but goes ahead and takes that risk anyway. There are some limited safeguards when the context needs to be taken into account in the dissemination, which can provide defences for established booksellers and libraries. It is irrelevant whether dissemination of the terrorist publication anyone is actually encouraged to commit terrorism, or the receiver understands its content, such as a file sent to a child who cannot access it, and if they do, cannot grasp its meaning. The maximum sentence for the offence is 15 years in prison. The terrorist publication, which is a direct or indirect encouragement to terrorism, there are defences, including he can show that the terrorist publication did not express his views and did not have his endorsement. This defence is not available for the second type of terrorist publication, that is a publication which is useful to a would-be terrorist. So if a person shares a bomb-making manual with another, they can't simply say they did not intend to encourage terrorism or it did not express his views. Here the person may have another defence, such as they did not have access to the terrorist publication or they did not know the contents of the terrorist publication was when they shared it, as it came in a bundle of documents from a downloaded file and they thought they were sharing legitimate documents. 3 observations and comments are made about Section 2. Legally, terrorism is a contentious concept, especially when dealing with foreign affairs and unresolved conflicts, and therefore publications, that is tweets, WhatsApp, Facebook, signal messages, can all fall within acts which encourage terrorism depending on the government's position at that moment. Secondly, the way Section 2 has been written makes it easy to prosecute and causes problem for defence who wish to defend their actions, because it brings into play how the receiver of the publication, whether they understood what has been sent to them or not, rather than a pure focus on the defendant's state of mind when they sent out a message. And thirdly, Section 2 does not appear to be used regularly enough to charge particular defendants who clearly share posts to incite racial or religious hatred, violence and killing of particular faiths and backgrounds, such as posts which promote the burning and attacks of religious places of worship, but are more likely to be investigated and prosecuted under the less stigmatising and less serious Public Order Act offences. Thank you for watching. Please subscribe to Community Legal Education. Please speak to a solicitor if you need legal advice, and may the justice be with you.